hand. Well, I would go further than recognition and say coming into leadership. And to note, as you know, my leader said a while ago, she's indeed the youngest member of the Campion College Alumni Hall of Fame. So I extend my own welcome to Senator Bunting. So, Mr. President, I am indeed pleased to present to the Senate on the Dangerous Drugs Amendment Bill 2020 and the Evidence Amendment Bill 2020. They are companion bills and we will be debating them simultaneously. I had occasion to raise a matter with Senator Bunting a while ago to bring to his attention for the benefit of his team some amendments that we would be bringing, because as we've often stated in this chamber, we make sure that we put forward the best legislation possible. We take all views on board. We don't necessarily accept all views, but they're certainly put forward for debate, and we do our best to put forward the best legislation possible. I'm not of the view that the amendments that are here before us fundamentally change the substance of the bill, but rather function as a measure of tidying up, for want of a better term. So it is my hope that the members of the opposition will be able to work with us to carry it to conclusion. However, it will not be a contentious issue if there are indeed views that the amendments put forward require a little more time for all members to fully ventilate them. But we would like to carry it to conclusion if, at the end of my presentation and certainly the end of opposition response, members are comfortable with the amendments for consideration. We would like to carry it to conclusion, but if members need more time, we won't make it a contentious issue at all. So the amendments will enable, Mr. President, drug samples and photographs of evidence to be received as evidence of large exhibits in court proceedings. Important and as background, the amendment to the Dangerous Drugs Act and the Evidence Act has arisen as a result of a concern expressed over significant time by the Jamaica Constabulary Force about the storage of evidence required for trial. The JCF expressed that there are issues regarding the duration of storage required, as well as their capacity to do the same. Consequently, consultation was undertaken with the relevant stakeholders, namely the Office of the Director of Public Prosecutions, the DPP, the Chief Justice, the Jamaica Bar Association, and the Advocates Association as far back as the 2015-2016 financial year. The positions of the stakeholders have informed the amendments to reflect the process concerning the destruction of dangerous drugs prior to the completion of the trial process, as noted and as is the case in Section 54A of the Dangerous Drugs Act of Trinidad and Tobago, and the guidelines in relation of the custody of drugs issued on December 11, 1996, under the signature of former DPP Glenn Andrade, QC. The amendments are geared towards facilitating the retention of samples only for trial in order to ease the challenges faced by the authorities regarding not just the storage of evidence, but the transportation and the logistics surrounding said seizures. The amendments proposed in the acts before us today are: one, to amend the Dangerous Drugs Act to provide for secure storage of drugs seized under the Act, allow for the seized or the drugs seized to be destroyed, and in any case where such drugs are required as evidence, for samples and images of the drugs to be taken before the drugs are indeed destroyed, and for those samples and images to be received in evidence have the same probative force as the drugs would have had if proved in the ordinary way currently. And two, to amend the Evidence Act to provide that in any case where a thing is seized as evidence, a sample or image of the thing may be taken by or under the direction of a constable and for the sample or image so taken to be received in evidence to have the same probative force as the thing would have if proved in the ordinary way. Colleagues and Mr. President, the JCF and indeed the Ministry of National Security has indicated their support for the amendments for the following reason. From an operational perspective, the proposed amendments will provide welcomed reform to the process of securing and submitting evidence in drug cases. The amendments will ensure that evidence is meticulously procured and curated for admission and acceptance in the courts. Samples, images, certificates, and records tendered in evidence have the same probative force as the drugs would have if proved in the ordinary way. This will eliminate the need to transport the large quantities of drugs to and from the court, eliminate also the unfortunate occurrence where drugs that have been seized have found their way back into the illegal trade. So it will reduce possibility of corruption, eliminate or minimize evidence tampering, and reduce the need for large storage and prevent storeroom congestion. The practice of storing large quantities of drugs for inordinately long periods will simply no longer exist. The Dangerous Drugs and Evidence Acts, respectively, provide for seizure, scientific analysis, certification, and rendering of drug evidence in court proceedings. However, there are no specific provisions treating with an admission of sample evidence as representation of the whole body of evidence under consideration. Instead, there has been occasional exercise of judicial discretion through which other evidence was considered to ground the finding of the facts that the drugs as evidence existed. Additionally, as previously mentioned, Mr. President, a set of guidelines, as had been outlined by DPP Glenn Andrade, have been adopted and updated by the current DPP, Paula Llewellyn, for the handling of drug evidence. And these guidelines were adopted by the JCF and included in their force orders, Order 2590, dated January 23, 1997. The underlying principle of the guidelines is that where drugs are seized in a criminal matter, the drugs are kept in proper custody and produced for trial. Where the drugs seized consist of packages, it is sufficient for evidentiary purposes for all packages to be photographed and samples taken from each package of the government analyst, and a representative sample from each package kept for evidentiary purposes. The drugs are only destroyed where no arrests were made and/or there is no possibility of an arrest being made. There is no difficulty with the destruction of the drugs where arrests are not made or are not possible, Mr. President. The issue arises when there has been an arrest and the drugs are retained for trial, which can take a considerable length of time from arrest to final appeal. As a result, these illicit drugs have become a serious problem for the logistics management of the force. By an opinion, the Attorney General's Chambers in 2003, it was submitted that the Force Order 2590, dated 23rd of January 1997, should be codified, as while they were practical and appropriate, they did not have force, the force of law, and could not guarantee acceptance by the defense in a case before the court. Further, the Advocates Association of Jamaica was of the view that it was necessary that a unified standard for the treatment of seized material should be implemented, and recommended that we adopt the relevant provisions in the Dangerous Drugs Act of Trinidad and Tobago, Section 54A, as mentioned earlier. Therefore, by Cabinet Submission number 85 MJ8-16, Cabinet was asked to consider and approve the proposal to amend the Dangerous Drugs Act and the Evidence Act to enable drug samples and photographs of evidence to be meticulously procured and curated for admission and acceptance in court proceedings as evidence of the existence of a larger exhibit. By Decision 816, dated March 21, 2016, the Cabinet endorsed proposals which were informed by the DPP guidelines, recommendations of the Advocates Associations, and guidance from the UN Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances of 1998. Mr. President, and I will just use this opportunity to acknowledge, Madam Leader, the work of the team, because it's a related issue. the recent reclassification of marijuana and marijuana resins by the CND, because it is relevant to the discussion we are having, and it is something that has long been fought for. I know my own experience in working with the team from Foreign Affairs and the team from the CLA. I think it's a proud moment to see that the work of the team resulted in that reclassification. It's absolutely important to the cultural issues. No, I know, only on Schedule 4, but agreed, on Schedule 4, but it's a step in the right direction, and it resolves some of the cultural issues and the inequities that have faced our people as it relates to marijuana. So it's important to note and to acknowledge the teams that have worked over years to get to this point, and to know that the work continues. The local situation, Mr. President, is well known. In recent years, the progress of disrupting the flow of drugs from South to North America by way of Central America have pushed drug trafficking back at alarming rates into the Caribbean, as the suppliers have sought alternative but former routes. This has made countries like Jamaica more vulnerable to trafficking in drugs, guns, ammunition, contraband, and unfortunately also humans, resulting from weaknesses in law enforcement structures and border security institutional capacities, as well as inter-country collaboration in the protection of their respective borders and maritime domains. As a result, this has led to increasingly high levels of crime and violence, often linked to international organized crime, such as drug trafficking, which has become an ever-increasing threat in the region. Illicit drugs and guns for trade and guns for drugs trade, as well as money laundering, represent very lucrative activities that have motivated their continued issues within our local jurisdiction. Jamaica's geographical location, as we all know, is one of the most attractive features for good and bad in Jamaica. The island has one of the largest seaports in the region, and our location between regions producing cocaine and the consuming destinations has come with significant costs. The island is one of the transshipment points, unfortunately, for good and bad products, including South American cocaine destined for North America and Europe. Traffickers continue to do what they can to breach our borders and cause significant issues. As a result of the link between the lucrative drug trafficking trade and the guns for drugs trade, the perpetuation of crime and violence on the local landscape, it is imperative that these perpetrators are charged and the matters taken to court. Now, we need to ensure that when they are taken to court, that the evidence that is brought before the courts can be accepted in a manner as prescribed by the amendments here before us today. Additionally, the link between the drugs and arms trade is strongly evidenced in the Caribbean region. In 2020, the JCF Narcotics Division reports that the guns for drug trade continues to be a major obstacle in the JCF's aims to reduce serious crime, especially murders, as these traffickers often exchange ganja for guns, with Haiti and other countries. Over 185 unmanned points of entry exist, or launch points, as we are all, or should all be aware. Over the past 12 months, colleagues, Jamaica has seen multiple seizures at our ports of entrance and exists with false compartments used as concealed methods, with people trafficking directly in small quantities, with all sorts of attempts to breach our internal security mechanisms. We'd have even seen recent seizures which would significantly change our annual average for narcotic busts in this manner. The Senate can be aware that 743 persons have been arrested year to date for attempts to traffic illegally traffic narcotics. Transnational organized crime networks, Mr. President, are expanding and diversifying their activities, resulting in the convergence of risks and threats that are increasingly complex and destabilizing. The trafficking of illicit drugs and illegal guns are still the primary activities of transnational organized crimes in the region. Mr. President, I make this point, or have given that context because the acts before us, though short and though seem to refer to procedural issues in how the cases are tried, have far deeper reach, because the impact of having evidence that is accepted and not running the risk of evidence tampering and ensuring that these persons, when caught and are brought before the courts, are tried and found guilty, is particularly important to the national security effort and impacts the safety of Jamaicans. Mr. President, the amendments will expand the 1996 practice directions and codify them into law. They will allow for the court to order the destruction of seized drugs generally, provided that appropriate samples of the drugs have been taken safely and are adequately secured. The amendments will also allow for sample drugs to be admitted into the evidence, as well as photographs, videotapes, compact discs, laboratory analysis certificates, or other such means which can be used to verify and document the identity and quantity of the drugs and substance seized by the police. All of these would be deemed admissible in court proceedings, as if the total quantity seized has been admitted into evidence. Now, Mr. President, specifically as it relates to the bills before us, the Dangerous Drugs Act, as it is outlined, is not a long piece of legislation, but it amends the Principal Act. And if you will allow me, I would like to go through the clauses and the amendments to those clauses as I'll present this afternoon. Mr. President, in the Dangerous Drugs Amendment Act, Clause 2 seeks to address the securing and disposing of drugs seized, outlines the information that is to be recorded when drugs are seized, and goes on to empower a constable and others above the rank of superintendent to authorize the destruction of drugs in specific instances. Mr. President, the clause describes the circumstance in which the court will authorize the destruction of drugs and provides what evidence is to be taken for such destruction. The clause provides the manner in which recorded images and samples will be admissible in evidence in court. The clause also gives the minister regulation-making power in particular instances, which is an important point. Now, if you'll allow me to go through the amendments to the legislation before us, before I get into the Evidence Act, and I will take my time with this in the hope that both sides are comfortable with what is before us, so we can hopefully get to committee stage. If not, I understand, because it would have been hoisted on persons. The first amendment, insertion of new clause 1A. Insert next after clause 1 the following clause. Section 21 of the Principal Act is amended. A, in subsections 4 and 5 by inserting next after the word premises, wherever it appears in each case, the words or other place. And B, by inserting next after subsection 6 the following subsection. In this section, place includes a conveyance. Clause 2. Clause 2.1. In subsections 1, 2, 3, and 6 of the new section 2A, insert in each case after the words section 21, 4, and 5, the words or any other law. In essence, this will give room for those who are not constables but in the position to seize narcotics, whether officers of MOCA, customs officers, JDF, even as we have found on occasion teachers who have had to search students in school. It will allow for seizure once their respective acts allow for it, as there would have been an issue with constable as it was mentioned there. 2, in subsections 2B and 7B2 of the new section 21A, In each case, delete the words government chemist or analyst designated under Section 17G of the 17 of the Food and Drugs Act, and substitute therefore the words public officer who is assigned to perform duties in the Institute of Forensic Science and Legal Medicine. The appropriate person would not have been the government chemist, and that is what that amendment seeks to correct. We will also insert a new clause 3. Insert next after clause 2 the following clause. Section 27 of the Principal Act is amended by deleting the words government chemist or analyst designated under the provisions of Section 17 of the Food and Drugs Act, and substitute therefore the words public officer who is assigned to perform duties in the Institute of Forensic Science and Legal Medicine. So this too corrects the same issue that we would have found in the Act before us on the Dangerous Drugs Act. It is not contemplated at this stage for any amendments to the Act to amend the Evidence Act. So with that, Mr. President, I will close and invite members to contribute to the debate. Thank you, Mr. President.
Thank you, Minister Samula. Senator Bunting.
Thank you, Mr. President. Mr. President, these amendments are welcomed. I well recall during my period as Minister of National Security, I was often concerned with the risk of the safe storage of large quantities of high-value illegal drugs, particularly as the court cases dragged on for many, many years, and the quantities being seized, kept going up, being seized and stored would keep increasing. This will also address another problem that we had. Thank you. This will also address another problem that we were faced with. Members will recall a piece of legislation, the technical name escapes me now, but it was referred to as the Shipwright Agreement. And it essentially allowed our international partners to patrol in our exclusive economic zone, or even to intercept Jamaican flag vessels on the high seas. But we had significant challenges in getting prosecutions for the nationals who were returned to Jamaica, because typically how it would happen is that the U.S. Coast Guard or the British Navy vessels or Coast Guard vessels would intercept Jamaican flag vessel carrying contraband. And if the nationals were to be returned to Jamaica, they would typically be met by the Coast Guard at an intermediate point by the Jamaican Coast Guard. The nationals would be exchanged. A sample of the drugs or whatever the contraband was would be turned over to the Jamaican Coast Guard, but the bulk of the contraband confiscated would be kept for destruction by the U.S. Coast Guard. And it was one of the challenges that we had under the current Evidence Act and Dangerous Drugs Act to get convictions of the Jamaican nationals who were returned to Jamaica, but because there was typically some issues were contested about what the actual evidence was and the quantities, etc. So this would also help in that regard. But if we move away from the dangerous drug amendment and just the evidence amendment, that has even wider application. As the son of a farmer, I was sensitive to the fact of what's called predial lasting, but really I mean, when people are taking truckloads of cows or livestock, it's a lot more serious. It's really organized crime. And farmers, in a sense, would often become double victims because their goods or their livestock would be stolen. And if the thieves were even caught, oftentimes they couldn't get back the goods or the livestock, in many cases the carcasses of the livestock. So they, because it had to be held as evidence. And oftentimes, again, if the animals were slaughtered, the police station wouldn't have the facilities to store it. And again, it created significant challenges in terms of a successful prosecution of these criminals. So the need for this is, self-evident. And I would start by the first question I'd ask the minister, without getting to the amendments to the bill itself. But I hope that the Evidence Act goes beyond, the amendments to the Evidence Act goes beyond just being a companion bill for the Dangerous Drugs Act, but for offenses that are outside the Dangerous Drugs Act, that it still applies in cases, for example, in terms of theft from farmers, theft of livestock or goods. Because if it does, that will help mitigate the loss that the farmer suffers if he can get back the vast majority of the goods stolen and only a sample is retained for purposes of the prosecution. But the truth of the matter is, as important as these really are talking about relatively modest administrative improvements. And when you look at the bigger crime picture, I was hoping that the minister would have shared some more with us in that area. Because I suppose I've recently got the crime statistics, the serious crime statistics from January 1st to December 12th, 2020. And to the extent there is a silver lining for security from COVID and the lockdowns associated with COVID, is that there has been a significant reduction in robberies and break-ins, both down around 18%, which in a sense you would expect, because if people are spending more time at home, there's less opportunity for thieves to break into their homes and their premises. And also because of the extensive island-wide curfews, very restrictive times, etc. And we welcome those gains. However, the serious categories of violent crime, that is the murder and the shooting in particular, have not similarly benefited. Murders this year relative to last year, 1,251 up to December 12th. That's a small reduction of 2% relative to last year. Shootings, 1,223, a small increase of 1% relative to last year. So relative to last year, things are pretty much the same.
In a pandemic year.
Despite 3 years of states of emergency, etc. However, don't let these small percentage movements or the flatness deceive you. Because when compared with the 2012 to 2015 period, the number of murders up to December 12th has already far exceeded the worst year during that time. So with 3 weeks to go, we're already way ahead of any year in terms of the number of murders in that 2012 to 2015 period when there were no states of emergency and when resources were a tiny fraction of what they are now. Now, Mr. President, the government has relied overwhelmingly on the serial and routine use of states of emergency as a long-term crime-fighting tool. And Minister Johnson, you will find out that there's a certain amount of fungibility to debate time. I wanted to enter upon a reference this morning to look at the constitutional, the judgment of the Constitutional Court, of the Supreme Court in the Everton, Douglas and others versus the Attorney General's ruling and the implications for our security situation. Since you seemed concerned with time then, I will take the time now because it's specifically relevant to the issues we're discussing. This case...
Sorry, on a point of order, though, Mr. President, I understand that that the government has filed an appeal in the matter, and if the matter is sub judice, it's the matter before the court, then under the standing orders, it's not appropriate to discuss it here. So while I understand your interest in the matter and your desire to discuss it, Mr. President, the matter is before the court. It's a matter on which the government has appealed.
When was the appeal filed?
I would have to get that date, sir, but...
Well, I've not heard of an appeal being filed, but Mr. President, in any event, I'm not saying anything that will prejudice the particular case.
The standing orders say that
could you refer
a
me to
matter should not be discussed.
Order?
It can be discussed, but not now we to prejudice. In other words, and plus because in the appeal court, you don't have juries and all of that. Nobody waste time on that, Minister. And I'm sure that nothing will be said now.
Yes.
No.
Standing Order 35(2) says that reference shall not be made to any matter on which a judicial decision is pending in such a way
as might.
In the opinion of the chair, not in your opinion.
But you
in the
haven't given me
opinion
a
of the
chance
chair,
to say
prejudice the
anything, so
interest
how
of
do
the
you know
parties.
what I'm going to say?
It is inappropriate. So, you know, I don't know if you want to start off by walking a fine line to debate constitutional issues in the Senate
Senator Bunting.
when they're before the court.
Yes, sir.
Mr. President, my point of order is asking that on the basis of 35(2) that the senator discontinue this line of debate.
So what is the president going to rule on? He has not said anything, so what is the president going to rule on?
To ask him to discontinue that line of debate on the basis that it is before the court.
All right, Senator Bunting, my ruling is that you tread cautiously in respect to the comments that you make, and if I see that you are going to cross the line, I will stop you at that.
If you're going to embarrass the government,
Thank you very much, Mr. President.
if you're going to embarrass the government, you're going to stop it.
Mr. President, the comments I intended to make, and which I will make, merely recites the findings of the law court, which is in the public domain already, and reciting them cannot prejudice the appeal. So, essentially, as I mentioned this morning, the court found that the situation which led to the detention of the detained men did not qualify as an emergency or satisfy the situation described in sections 20, subsections 2 and 5 of the Constitution. It further found that the Emergency Powers Act in its current form does not apply to the current Constitution, since it A, makes references to section 26 of the Constitution, which was repealed, B, does not qualify as a law for the purposes of Section 13 subsection 9. C, the Emergency Powers Act is in conflict with the Constitution. And D, there's no savings law or modification clauses to assist the court. The third important finding was that the Emergency Powers Regulation in its current form does not apply to the current Constitution, since it was passed pursuant to powers from a legislation that cannot be utilized to pass the Emergency Powers Regulation. And finally, Mr. President, it found that the detention order for the detained men mentioned was unlawful, since it was passed on the strength of the impugned EPA and EPR. And finally, further, the imprisonment of a claimant for criminal cases without a proper review breaches the separation of power doctrine. Now, I had not previously heard that the government has appealed the decision. This, I don't think it was covered in the media because I'm not aware of it. So I would ask the minister when he replies, or the leader of the Senate, to give us further and better particulars in that regard. But without going further, where we are now, and the point I wish to make is that operationally, for the time being, the government cannot continue to use the states of emergency as a routine crime-fighting tool. The judgment came down in September. This year was handed down in September, if I recall. And therefore, we have had 3 months for the government to tell us what are they going to substitute for this. Because even if an appeal is heard, that will take some time. And if it's filed, it will take some time to get a judgment on it. So in the meantime, we see murders continuing at an unacceptable pace. So what I would like to hear from the government is, what is the replacement strategy for this serial and routine use of the states of emergency, which we warned was not sustainable from a constitutional perspective, but even from an operational effectiveness perspective, because we still have had not one single year under the states of emergency where extreme violent crime, murder and shooting was as low as it was in the previous administration when we had no states of emergency. And when we had, and I've made this, pointed this out, in the 2019-2020 financial year, the capital budget for the Ministry of National Security was 10 times what it was in any year during the 2012 to 2015 period, when we were getting better outcomes in terms of reducing violence. So, Mr. Speaker, I hope to hear, Mr. President, rather, I hope to hear...
Remember, you're not in that other place.
and I apologize in advance, because after 4 terms, it's going to take a while for me to shake that habit. But Mr. President, I think it is important that the government tell the nation what is the substitute strategy, because people continue to be anxious, even in this COVID time, even in this Christmas season. The daily reports of the numbers of murders or the deaths from violent crime are exceeding anything else. And it is a cause of great anxiety and concern, and we would like to hear from the government in that regard. Specific to the suggestion or the question, I suppose, posed by Senator Samuda. I don't want to speak on behalf of other members, especially those members who would not have had the benefit of the technical assistance to absorb the proposed amendments to the bill. But since the bill is without regulations and cannot come into operation without the regulations, and since the amendments would have to go back to the House anyway, which was not meeting again for the rest of this year, I think for good order, we should get the amendments typed up. In fact, we might even, incorporate them, make it easier, incorporate them in the actual bill itself, and we deal with it early in the new year. I don't think it will prevent anything operational from taking place, because as we have seen, sometimes years elapse between the bill and the regulations that go with the bill. Now, this is not a complicated bill, so hopefully the regulations can come more quickly. But so soon as the regulations would come, by then we could deal with the amendments to the bill in any event, and it wouldn't result in any delay from an operationalizing standpoint of the benefits of these bills which are being considered today. May it please you, Mr. President.
Thank you very much, Senator Bunting. Senator Samola.
Yeah, man. Well, I didn't mention
Minister.
Mr. President, only one other contribution to the bill before us today, and I thank the member for his contribution. I admittedly had hoped that, because as he had said, the bills before us were not complicated, that we could complete the business of the Senate. That was before us, before the closing before the new year, so that we'd be able to start with a fresh list of public business. However, we will not make it a contentious issue. What I will do is close the debate today, and we'll go to committee when we come back, because the amendments would have been circulated and there'd have been adequate time to. Well, it's the intention. I didn't realize if there are other members who are intent on speaking, then I will not close. Right. I will suspend. Maybe perhaps I misunderstood what you were saying.
May I assist you?
Sure.
May I assist you, Mr. If whether we close the debate today or not wouldn't really matter, because every member would have a chance to speak on the amendments anyway, because you're bringing amendments, so they would be able to speak on the amendments. So, in fact, after the amendments come, just for good order, just take a point of order to speak on the amendment. So, whether you close it or not, I would suggest you don't bother close it. Leave it open, so other members, when they see the amendments, they can participate. Or if you close it now, we will have to have a debate on the amendments anyway.
So, Mr. President, we will leave it open. As I said, we won't make it a contentious issue. At the end of the day, the Senate does believe in putting forward the best bills possible, and because of the nature of how the amendments would have been circulated, I will allow for that, with the intention to bring it to a closure. I mean, it's not, and to be frank, it is really just in the spirit of cooperation, because I didn't think we would have needed the additional time. So I will save my response and closing, and will just note before suspending or before asking for the suspension of the debate that I do look forward to responding to the SOE comments and matters of security and performance. And just for the record, Mr. President, the appeal to the ruling to which the leader had made mention in her point of order was filed on October 29th, Mr. President. Thank you.
All right, thank you. So we will be having a suspension of the debate on these two bills, the Act to amend the Evidence Act and the Act to amend the Dangerous Act. Yes, yes. You're trying to predict the future, Senator Brown? All right. So the question is that the debate be suspended on these two bills, the Act to amend the Evidence Act and the Act to amend the Dangerous Drugs Act. All in favor? Any against? The ayes have it. Leader?
It is not. Mr. President, I have literally been counting down to this moment. I know it's, we were just at an event recently, the ladies, where we were reminded that it was the first woman who, to sit in Parliament, Iris Collins, who changed the standing orders that required that women wear headwear to Parliament. And she broke the mold, broke the train, and no more headwear was required. It's only now a choice on ceremonial occasions. But today I know colleagues colleagues will just in the moment. It's been such a year. It's been such a year for all of us. It's been a year for Jamaica, and it's indeed been a year for the world. But there is some cheer to be found at Christmas time, whether it is peaceful, quiet reflection, whether it is family time, whether it's time with friends who are family, whether it's time spent prayerfully or in finding ways to help less fortunate, which even that has been COVIDified. And how we do that may not necessarily have the emotional impact and feeling that we all tend to pull from giving, the act of giving at Christmas time. But today, Mr. President, I just want to wish colleagues on both sides, all of the parliamentary staff, or Hansard staff, orderlies, and of course the clerks, everyone, our marshal, captain, who has recovered to us from the other side. And of course the media who has joined us today and has followed our sittings and has faithfully reported them to the public, to security, to our police, to the staff of the parliamentary cafeteria and the chefs who feed us on a weekly basis. I want to say a very Merry Christmas. Very, very Merry Christmas. I wish you and your families every blessing, a safe, healthy, holy, peaceful Christmas, and a prosperous and above all, healthy New Year. Thank you, Mr. President.
Mr. President, on behalf of the opposition, I would like to join in the remarks, to associate the opposition with the remarks from the leader of government business, and to make a special recognition of the parliamentary staff. They are part of they're part of the essential services that don't have the option to work from home. And they have to come out, many have to take public transport and expose themselves so that the business of the country can continue, the legislative business in particular of the country can continue. And I certainly use the opportunity to add my support to the words of Senator Brown earlier, that we as a body should lobby on behalf of the team to see if they can get a more just and appropriate remuneration in the new year. And it's just then for me to wish colleagues in both houses and the wider Jamaica, including my friend, the Minister of Justice, a safe, happy, holy Christmas season. Be careful out there, COVID still a keep, and improved and successful 2021. Thank you.
Mr. President, I just have one point to raise, which is only of concern, sadly, for some members of the Senate, and that is that now that we have appointed the Joint Select Committee for the NIDS bill, we have a meeting now. So I'm serious. So they couldn't send the notice because you weren't appointed. We weren't appointed. So so just to ask, that the Chambers is going to change mode very quickly right now for us to have a brief procedural meeting. But to everyone else, your festive season begins. On that, I ask Mr. President that the Senate be adjourned for a date to be fixed.
The question is that the Senate be adjourned for a date to be fixed. All in favor? Aye. I won't ask if any is against. The ayes have it.
We remain resilient in our fight against known and unknown threats to our country. We are never daunted.
We are committed to continuously deliver